Second, AB 692. This is a ban on what are known as stay or pay agreements. And some of your organizations may have used these in the past, maybe with some of the ministerial employees, people that you're recruiting to come from out of state, and you say, hey, we're willing to pay you a bonus or some sort of compensation, but if you don't stay for, let's say, 2 years, you got to pay us back, right? That's what a stay or pay agreement is. And, what happened was, and I've had this from clients over the last years, everybody was trying to put the square peg in the round hole with this. And, I had to spend a bunch of time training my employees, and that's a cost to the company. So if the employee leaves within 2 years, they should agree to pay me back the training costs. Okay? I am sending this employee out to training, but it's training that I'm requiring for them to be able to perform their job. But if they leave after I make this big investment, I want them to pay me back. And so the legislature stepped in and said, no, we're not going to allow that anymore. So what this legislation says is that any employment agreement that has to do with training, tuition reimbursement, relocation fees, licenses, we are not going to enforce it. It is going to be considered illegal as of, again, if it's entered into after January 1st. Okay? So a current agreement does not fall within this law. But if you're an employer, and again, this applies to all employers, after January 1st, 2026, and you make an employee sign one of these agreements, it is illegal, it is void. So that's what the law says, unless it meets certain requirements. So it is unlawful to require an employee to execute one of these agreements to pay a debt or incur a penalty or a fee or a cost if the employment terminates. Now, there are some exceptions, which we will talk about. But again, the penalty is pretty severe. Violations can result in actual damages to the employee or $5,000, whichever is greater. And here's the kicker, plus attorney's fees and costs. So if an employee sues saying, hey, you made me sign an unlawful agreement, and they win, their attorney is going to be entitled to an award of attorney's fees. And something I've mentioned in the past, since this is part of the labor code, you could hypothetically, if you had multiple employees required to sign unlawful agreements, be subject to a PAGA lawsuit, because it is a violation of the labor code, and therefore the employees can sue on behalf of other employees under the Private Attorneys General's Act. So we need to be really careful about this. Now, as I said, there are some exceptions. First big exception is tuition reimbursement. Okay? If the employee is getting a degree, some sort of credential, and the employer is footing the bill, you can have an agreement that they pay a portion of that back upon termination, but it's got to meet these requirements, okay? First of all, it's got to be separate from the contract of employment. So you can't slip it into the handbook. You can't have it part of an overall contract of employment. It's got to be a separate standalone agreement. Okay, number two, it's got to be a transferable credential that is not required as a condition of employment. In other words, it's something that the employee could use no matter where they were working as part of their career. as opposed to a specific certification that is required for their position. Okay? Number 3, the repayment amount has to be specified in the agreement, and it cannot exceed the cost to the employer for the tuition reimbursement. And if the employee leaves during the repayment period, it's got to be prorated, right? So if you're requiring the employee to stay 24 months and they leave after 18 months, then whatever they owe has got to be prorated based on the length of time that they worked there. In other words, they're only going to owe a quarter of what the repayment obligation is because they stayed 18 out of the 24 months. You can't accelerate it at the end. Oh, no, you left before the 24 months, so we're going to make you pay the full amount. Can't do that. If you terminate the employee, you can't go after repayment unless you can prove the employee engaged in misconduct. So I've got misconduct in quotes because what this refers to is under the unemployment code. Has anybody ever gone to unemployment insurance hearing with EDD to challenge somebody's unemployment? Right? What's the standard? If you want to challenge somebody's eligibility, either you got to prove that they voluntarily terminated or that they engaged in misconduct. It can't be just they were a poor performer. They had to do something really bad. Okay? So that same standard is what is adopted here. So if the employee quits, you can require repayment. But if you terminate and you require repayment, you've got a high standard to meet. So just be aware of that. So that is one of the exemptions. The second exemption is like hiring bonus agreements that are not tied to specific job performance, again, are exempted. If you say, hey, I'm going to give you a hiring bonus of $25,000 to move out here to California and to take on this job, but you got to stay 2 years. That can be an enforceable agreement if it meets the qualifications, the requirements. Number one, same as tuition reimbursement, it's got to be a separate agreement from the primary employment contract. 2, you got to give employees notice of their right to consult an attorney, and they have to be allowed 5 business days to seek advice prior to signing. So this is separate from the tuition reimbursement. For these types of agreements, you've got to have some advice there in the agreement itself, and you got to give them 5 days. Again, you've got to prorate based on the amount of time that they stay, and it can't exceed 2 years. So that's different from the tuition reimbursement. These types of agreements, you can't make them repay if they leave after 2 years. That's your limit. The employee has the option to defer until the end of the retention period, and the separation has to, again, either be voluntary or due to misconduct.